identifying international trade organization, which can be a subcategory of, say, international economic organizations, and you'll find WTO and other related international organizations there. Now, such forms of classifications are important, and this is the second aspect which I'm going to talk about. Such forms of classification are important, maybe not for a purely legal technical analysis, but from an academic point of view. While it has only academic value and it is well recognized in the existing literature, but it has significance in the sense that its impact, function, objective, membership can be easily discerned if at all we understand this logic of classification properly. Now, what is it that I mean by logic of classification, and the larger reason behind logic of classification is this: that each and every international organization is different. Therefore, we cannot put, say, something like United Nations as an international organization on an equal footing with that of, say, International Monetary Fund as an international organization, or, for example, European Union for that matter, or SAARC for that matter, or WTO for that matter. Why are these international organizations different? Is something. Just give me 1 minute. Let me switch off my phone. Yeah, sorry. Okay, now why are these international organizations different? Is because the constituent instrument of these international organizations are different. Now, those of you who have been attending lectures since the beginning of the semester would remember that while talking about the idea of constituent instrument, we said that each and every international organization is a product of a treaty, mainly a treaty or any other instrument governed by international. Fundamentally, in most of the cases, it is a product of a treaty, and the treaty which establishes an international organization is known as constituent instrument. Therefore, when we are saying constituent, what we fundamentally mean is that the specific document, the treaty, which has constituted an international organization, which has established an international organization. Therefore, the constituent instrument of United Nations as an international organization is United Nations Charter. The constituent instrument of World Trade Organization is Agreement Establishing World Trade Organization. Constituent instrument of IMF would be Agreement on International Monetary Fund. Constituent instrument of SAARC would be SAARC Charter. Therefore, each and every international organization can be traced back to one central document which establishes it. This is true for almost every single international organization in the world. There cannot be an international organization without, of course, a constituent instrument in one form or the other. Now, classification is important because all these international organizations have different constituent instruments. And since they have different constituent instruments, they reflect different kind of tendencies. When I say tendencies, what I mean by tendencies is tendencies in terms of functions, tendencies in terms of kinds, tendencies in terms of composition, tendencies in terms of membership, tendencies in terms of, say, legal personality, and the list could be endless. This is precisely what I mean by the need for classification. The need for classification is basically the need to understand an international organization in a much more precise manner, to group international organization in one heading and try to understand the features of international organization which would fit within that heading. This is the point which I wanted to make. And therefore, for international lawyers, what is fundamentally important is to recognize the fact that each international organization is unique, and because each international organization is unique, therefore it is very difficult to have a larger category. Many international lawyers claim a larger category of, say, international organization, and then try to understand all the international organizations in the same way, and say that there are something called international organizations, and all of them can be understood in terms of their powers, functions, classifications, membership on an equal footing. Of course, that's a much more contested idea. And therefore, for convenience, what international lawyers often do is that they pick up in these international organizations. They say that there cannot be a monolithic idea of international organization. all these international organizations are not carved out of the same stone. They are separately built. And therefore, for convenience, let's try to classify these international organizations in smaller categories. Although no classification can be accurate. At this point of time, I must emphasize on this point that because each international organization is different in many regards, uh, therefore, no classification can be an accurate classification. But there could be broader categories in which these international organizations could be classified, and these are the broader categories that we are going to talk about. So that's the first part of the discussion which I wanted to introduce. So there are 3 points which emerges out of the discussion which we had over the past 5 to 10 minutes. This one, classification is needed to understand the nature, function, membership, and other specific aspect of international organization clearly. For analysis, it becomes much more easier if we understand international organization in a much more classified manner rather than in a monolithic manner. The second aspect is that classification is an inevitable exercise because each international organization is unique. Each international organization is unique because each international organization has its own international legal personality. One cannot read agreement establishing World Trade Organization and talk about United Nations Charter because United Nations as an international organization is a product of a very specific constituent instrument. And the agreement establishing World Trade Organization establishes another international organization, right? So the features of these international organizations, the character of these international organizations is to be understood in accordance with the constituent instrument of this specific international organization. That's the point which I wanted to make. And therefore, just because there is an international organization, one cannot invoke a general idea of international organization on all of these specific bodies. Okay. Now, if that is the case, but again, the point which I'm trying to make is this: that no classification is absolute. Always remember that the classification which we are talking about is only a broader classification to understand the larger categories in which an international organization might fit in. Now, if that part of the discussion is over, then the next question, perhaps the most tricky question which comes before us, is that how classify? Fine, we can easily understand the meaning of classification, the need for classification, but that does not answer the most important, perhaps the most controversial question, as I said, and that is how do we classify? Now, when we are talking about how do we classify, there are different modes which are proposed to classify an international organization. And these modes involve, for example, classification on the grounds of functions, classification on the grounds of membership, and also classification on the grounds of the nature of work. And we will come to how, for example, political and technical kind of classification is often maintained. Let's talk about all these broader forms of classification one by one for our convenience. Now, when we are talking about classification, often there is a tendency, and perhaps the most dominant way of classifying international organization is by identifying their functions. Therefore, you will find that international organizations are classified in terms of those who work in economic field, those international organizations which work in the field of peace and security, those international organizations which might work in the field of military alliances, those international organizations which might work in the field of, say, public health, those international organizations which might work in the field of, say, telecommunication, fisheries, conservation, etc., etc. Because there is a proliferation of international organizations, therefore the list is also endless. Therefore, while we are talking about the classification of international organization in accordance with their function, there can be an issue with regard to defining the nature of the function itself. The point which I'm trying to make is this: that the same international organization might fit within 2 or 3 different classes. Therefore, if one says that a particular international organization, say Universal Postal Union, deals with communication of a particular kind, are we comfortably in the position to argue that this international organization is not related to economic affairs? Can we really say something like that? Now, this is a question which has immense value, especially in the light of a criticism which is generated about classifying international organization in terms of their functions. So the dominant mode of classification of international organization is classify international organization in terms of how their functions are placed. Say, as I said, political affairs, economic field, peace and security, telecommunication, fisheries conservation, the list could be endless. But the criticism which appears in terms of having a classification on functional lines is that can you really classify international organization on functional lines in the sense that one international organization, if not explicitly, then impliedly might interfere with other forms of classification as well. Say, an organization which on the face of it uh, looks looks like dealing with political matters or looks like engaging in political functions might have economic repercussions. Therefore, to give a more concrete example, United Nations Security Council's power to put sanctions, and not just military sanctions, but also say economic sanctions, might easily be said to falling within the ambit of economic affairs. Therefore, there's a strong view against this dominant mode of classification that classification on functional lines is always an incomplete exercise. That no classification could be complete, and it would be very parochial on part of the classifier to classify international organization in a functional sense. So that's the first argument which I wanted to mention in relation to how classification, in terms of how classification really works. Functional classification, therefore, to summarize this point, presumes that an international organization may have only one specific function, while ignoring the aspect that each function is connected or each function might be connected with each other, and therefore fundamentally making the strict classification on the ground of function almost redundant. Therefore, even if we are classifying international organization on functional grounds, there is every possibility that that an international organization might fit within, say, more than one heads of classification on the ground of function. The second major theme which appears in the discussion about classification is uh, is again a very dominant argument about classifying international organizations on the ground of membership. When we say classifying international organization on the ground of membership, what is it that we mean? What we mean is that there could be certain international organizations which could be open. There could be certain international organizations which could be closed. Now, an obvious question which arises here is by open international organization. When we say open international organization, what we mean is that the membership of that particular international organization is open to all the states for that matter. A closed international organization would mean that the membership of an international organization is fundamentally closed, meaning thereby that not all states can join that particular international organization. Right? Now, let me explain this point further. Those international organizations which are open to all the states are generally called as universal international organizations. What I mean by this is that, and to give a more concrete example, is something called United Nations. And similarly, you can find other international organizations. I'm not sure if one of you can check the membership of World Trade Organization. And you'll find that there are quite a few members of WHO. Similarly, if you can check the membership of World Trade Organization, if I remember correctly, Afghanistan, I think, became 162nd or 163rd country to join WTO way back in 2004. Sorry?
Sir, 164th.
164th country. Wonderful. Thank you. So now, because the membership is open to states in general, and again, this term is a very, very specific term. When we say states in general, we are talking about statehood. So not every territory, when we say states can become members of international organization, we are very, very particular in making that particular remark, that states can become members of international organization. In order to be classified as state, you need to satisfy the criteria of statehood under international law, which is an extremely controversial issue, of course. What is it that we mean by statehood? How recognition really works? Be that as it may, the exact question which we are looking at is that there are certain international organizations which are open to all the states in general, and their membership is, of course, and such states can become members of international organization. And mostly another term which is used for such international organization is that these international organizations have almost universal membership. But there are certain other international organizations or other types of international organizations which might not be open to all the states. These are mostly regional groupings or groupings which are issue based. Therefore, something like European Union or Organization of African Unity, or for example, Organization of American States, or for example, SAARC, what we have in South Asia. Now, all these organizations are limited to only certain states, while other states can apply for observer membership, which depends on the constituent instrument itself, whether the constituent instrument, that is the treaty which established that international organization, allows for observer membership or not. Else, these organizations are open to only certain kinds of countries. Now, when I say certain kinds of countries, you might say that how this certain kinds of countries, this exact phrase which you are referring to, is identified. Now, this may be identified on the basis of interest. That is, the constituent instrument may say that only those countries which are interested in contributing forces, for example, to this group, will be members of it. It might be based on economy, that this particular international organization welcomes only developing or least developed countries. It might be based on geography, in the sense that those countries falling within a particular geographical unit will become or can become member of such international organization. Or it might also be temporal, which many scholars don't talk about. I was a bit shocked to read Klabus's book, one of the most accepted textbooks when it comes to international organizations. When I say temporal, what I mean by temporal is that there may be certain international organizations, or at least there is a theoretical possibility, which says that only those states which engage in, say, establishing an international organization, the word which is used in this case is original members. So only those states which are original members of an international organization can be part of it. Now, this is the point which I'm trying to. So there could be an international organization which is open to all the states, and when I say states has to be seen in the light of larger statehood debate within international law. The second kind of international organization could be closed states, and this closeness could be subject to a number of subcategories like geography, issues, and other similar categories which I identified just now. Now, there's one more category which I'm tempted to talk about, that there could be certain international organizations which can go beyond states, which can say that in addition to states, other international organizations can be a member of international organization. Now, those of you who attended the first lecture would remember a discussion which we had when we were defining international organization. If you remember the definition of international organization we adopted for our class discussion from the International Law Commission's articles on the responsibility of international organization, we said that international organization is established by a treaty or other instrument governed by international law. That was the first point, which will have its own international legal personality. We also said that entities other than states can also be members of international organization. This was the point which we discussed in the first lecture. I don't know how many of you remember that. When we say entities other than states may also be members of international organization, the question which arises is, how do we determine if certain entities can be members of an international organization or not? Now, in order to determine whether certain entities can be members of another international organization or not, where do we go? How do we really identify that? Any response to that? Yeah. Okay, Shubham, I'm just coming to your question. That's a good question, of course. But before that, I mean, if any one of you remember the discussion which we had, that how do we decide whether entities other than states can also be members of an international organization? हमें कैसा पता चलेगा कि किसी entity, कोई ऐसी entity जो state नहीं है, वो दूसरे international organization और वो एक international organization का member हो सकती है? To put it in more direct sense, एक international organization क्या दूसरे international organization का member बन सकता है? States की तरह बिल्कुल. Yes, wonderful. Thank you, Shubham. Thank you so much for that response. Yes, through constituent instrument, as I've been saying regularly throughout the semester and even in this class, that what are the powers of an international organization? What are the functions of international organization? What are the responsibilities of international organization? How does institutional structure of an international organization? All these issues would be dealt, would be identified by looking at the constituent instrument of an international organization. To put it in simple words, if the treaty which has established the international organization allows for a possibility that other entities can also become member of an international organization. When I say other entities, what I mean by this is entities other than states. I discussed it in the first lecture itself. Then such international organizations would be open to membership from other entities. A good example, and those of you who were there in our international trade law lectures last semester would recognize the fact as to how EU, for example, is a member of World Trade Organization, an international organization, member of another international organization. That's the interesting dichotomy that we are looking at. So fundamentally, when it comes to classification on the basis of membership, we don't confine our imagination to close or open membership, but also in terms of the kinds of members which an international organization seek to attract. So to answer Shubham's question, do we have a name for this kind of international organization? There's no one particular designation which international law employs to imagine an international organization. What I'm trying to say is this, that the designation which international law gives to international organization is not based on their classification. The designation is subject specific. Therefore, if you are dealing with, say, something like WTO, so this designation World Trade Organization is not based on specific forms of classification on the grounds of membership, for example, but the subject matter which that organization deals with, that is trade. When it comes to trade, of course, it further classifies it into trades in goods, trade in services, intellectual property rights, and there are other such issues which are covered there. So no, there are no specific designations which are attached. But yes, when it comes to classification, often a classification is made on the grounds of kinds of membership, and in so doing, as we saw, that there is something called universal membership, there is something called limited membership, which depends on openness or closeness of an international organization. We also saw that the kind of entities which an international organization attracts in relation to membership also can also be a grounds of classification. Of course, such forms of classification are not dominant. When I say classification on the grounds of kinds of entities which can be part of an international organization, these are not dominant because there are not many international organizations which attract or which seek to attract other international organizations as its member. Please try to contextualize this entire debate in relation to the discussion we had in the first lecture. I've almost repeated those specific aspects, but we got more time to talk about how the question of membership is governed under international law, especially with regard to international organizations. Now, there's this another third form of classification which is often employed when it comes to international organization, and this is with regard to those international organizations which are considered as doing only technical works, and those international organizations which go beyond doing only technical works and also deal with political issues. International relations scholars are particularly fond of classifying international organizations in this. Let me explain this point which I'm trying to make. When I say that there are certain international organizations which go beyond merely classifying which go beyond classifying international organization on the grounds of, say, function or membership, and try to look at the nature of work and and how that particular work is important or not important for for international relations. Now the question is this: if you remember our initial discussion which we had in this class about the history of international organization, let me relate this classification to the history of international organization. You remember when we were talking about the 19th century development of international organization, I made that point that during the 19th century, the initial international organizations which developed were on issues like telecommunication, the governance of river courses or water courses, as it is famously known. And subsequent international lawyers looked at these international organizations as engaged in low politics. I don't know if you remember this particular word called low politics, which we try to explain. That is, those issues which are not of serious political character. Those issues in relation to which engagement is very easy between the states. Therefore, when it comes to, say, facilitating telecommunication, almost every state agreed that yes, let's facilitate telecommunication because it is easier for people to communicate and it would benefit all the states. Subsequent international, similarly, when it comes to governance of water courses, it was generally considered as less controversial issue, and it has not remained the same. We all know we live in South Asia, and we have witnessed how, for example, India's treaty with Nepal, Bangladesh, Pakistan, three countries have turned out to be extremely controversial in their own ways. Now, it is in this sense that initial development of international organizations happened on those issues which I would say were non-political, which were often identified as non-political, or were considered as, in a purely technical words, low politics. But with the growth of organizations like, say, League of Nations, so that now they are dealing with real political issue where the idea of collective security has gained immense value. Now, because of this distinction between the kinds of international organization which can evoke political sentiments and the kinds of international organization which do not, as a matter of policy, evoke political sentiment, there is a distinction which is often made, and therefore this is particularly used in relation to transport and communication, and so that look at the international organizations which are engaged in problems of transport and communication. I mean, these are less controversial issues, and therefore these international organizations are to be understood, are to be read, are to be analyzed differently from those international organizations which are much more political. However, there is a serious criticism within IR scholarship itself, which sees this particular classification as a very futile or incomplete classification. And the argument which is made in terms of criticizing this classification is this: that by classifying international organization in terms of political or technical, ignores the fact that those international organizations which on the face of it might appear as merely technical international organization could easily evoke political sentiments. And the example for that matter which Clausius gives is that of, say, fisheries conservation. So that for those countries where fisheries conservation is not a very serious issue, and if they are part of an international organization which deals with fisheries conservation, for those international organization, for those states, that particular international organization is dealing with technical issue only. But imagine a country which significantly relies on fisheries conservation. I mean, the economy of that country, if it is significantly governed by fisheries conservation, then of course it cannot be merely considered as engaging in, say, technical issue. Rather, it can also turn out to be an economic issue, a political issue having far more serious significance, evoking political significance, as it is often called, and going beyond merely technical questions. So this is the third form of classification which emerges in which emerges in discussions about international organization. In fact, the last type of classification, which I wanted to avoid, but it is too important to be avoided, and I thought of bringing this classification maybe subsequently in the semester. But let's deal with it now. It fundamentally is about intergovernmental or supranational kind of classification. Now, what is it that we mean by intergovernmental or supranational? This is a very important question. When we talk about intergovernmental or supranational, I will take you back to again the first lecture of this particular semester, where we were trying to define international organization. Now, in defining the idea of international organization, if you remember, we said that international organizations and Vienna Convention on the Law of Treaties between States and International Organization and between International Organization, 1986. Again, let me make that point again. That don't confuse between the VCLT 1969 and VCLT IO 1986. Many a time students get confused. I've seen students making that mistake when they are putting these ideas in their answer sheets, where they get confused between VCLT 1969 and VCLT IO, that is Vienna Convention on the Law of Treaties between States and International Organizations and between International Organizations, 1986. And we have already spent at least 10 to 15 minutes in making that distinction very clear in initial lecture. So anyone who would like to revise that for the entire class? Anyone who remembers that discussion?
मैं नहीं करता, याद नहीं है सर.
Anyone? You don't remember it? Yes, yeah, please go ahead.
So you said in the first class about the definition in VCLT-IO, there was the definition that international institution means intergovernmental institution. That is defined in the VCLT-IO 1969. And VCLT in 1986 is something different. That is about the Vienna Convention of Law of Treaty only.
No, so the question which is there, that what is the distinction between VCLT, that is 1969 Vienna Convention on the Law of Treaties, and the 1986 Vienna Convention on the Law of Treaties between states and international organization and between international organizations? Is there a distinction between the two? Any idea? Yes, it has not been enforced, but in substance, yeah, thank you, both Isha and Shubham, thank you so much for that response. But is there any other specific distinction?
VCLT 1986 was simply a treaty, but VCLT IO is something that is between states and international organization, and between international organization and between states. Maybe I'm not too much clear about it.
Okay, fine. I've already talked about it. When it comes to VCLT 1969, VCLT 1969 basically deals with treaties which are concluded between two or more states. So what we have in mind when we are talking about VCLT 1969, we are fundamentally looking at those treaties. And when I saying fundamentally looking at those treaties, that means that we are dealing with, say, adoption, signing, ratification, implementation, interpretation, invalidity, denunciation of treaties which are concluded between two or more states. जहां सिर्फ स्टेट्स की बात हो और स्टेट्स के बीच में जो ट्रीटी रिलेशंस है उनकी बात हो, और ये सारे मुद्दे जो मैंने अभी बताए हैं, जहां इंटरप्रिटेशन आता है, इम्प्लीमेंटेशन आता है, इनवैलिडिटी आती है, डिनंसिएशन आता है, वैसे मुद्दों के लिए वियना कन्वेंशन ऑन द लॉ ऑफ ट्रीटीज 1969 है. 1986 ट्रीटी, 1986 वियना कन्वेंशन जो है वो इन्हीं सारे मुद्दों को गवर्न करता है, जो मैंने बताया, अडॉप्शन, कंक्लूजन, रैटिफिकेशन, इंटरप्रिटेशन, इम्प्लीमेंटेशन, इनवैलिडिटी, डिनंसिएशन, लेकिन उन ट्रीटीज के कॉन्टेक्स्ट में डील करता है जो जहां पर इंटरनेशनल ऑर्गेनाइजेशन एक पार्टी, इसका मतलब कि एक ऐसी ट्रीटी जहां एक स्टेट और इंटरनेशनल ऑर्गेनाइजेशन पार्टी हो, या फिर बहुत सारे स्टेट्स और इंटरनेशनल ऑर्गेनाइजेशंस पार्टी, या फिर एक ऐसी ट्रीटी जिसमें सिर्फ इंटरनेशनल ऑर्गेनाइजेशन ही पार्टी हो. दो इंटरनेशनल ऑर्गेनाइजेशन के बीच में मान लीजिए ट्रीटी, वैसे ट्रीटीज को गवर्न करने के लिए और इन स्पेसिफिक मुद्दों को जो मैंने आपको बताया, अडॉप्शन, कंक्लूजन, रैटिफिकेशन, सिग्नेचर, इम्प्लीमेंटेशन, इंटरप्रिटेशन, इनवैलिडिटी, डिनंसिएशन, उसके लिए एक दूसरी ट्रीटी, उसके लिए एक दूसरा इंस्ट्रूमेंट जो बनाया था इन्होंने, वो था वियना कन्वेंशन ऑन द लॉ ऑफ ट्रीटीज बिटवीन स्टेट्स एंड इंटरनेशनल ऑर्गेनाइजेशन एंड बिटवीन इंटरनेशनल ऑर्गेनाइजेशन. This is precisely the point which we talked about in the first lecture, that please don't make the distinction. I have done it multiple times in my public international law lectures. I'm doing it here. But if at all there is a confusion, feel free to intervene and ask. Okay, Shubham, 1986 convention has not been enforced. Yes, it is still not enforced, but 1969 is enforced. India is not a party to it. Yes, 1986 seeks to govern IO relations as well. Wonderful. It goes beyond treaty made between only two states and talks about treaties where international organizations could be a member. Such possibilities would include a treaty where one state and one international organization, or more than one states or more than one international organizations are members, or such treaties where only international organizations are members, right? जहां सिर्फ स्टेट्स मेंबर्स हो, एक ऐसी ट्रीटी जिसमें सिर्फ स्टेट्स ही मेंबर्स हो, वैसी ट्रीटी जो गवर्न होती है वो वीसीएलटी से होती है, वीसीएलटी 1969 से होती है, जहां इंटरनेशनल ऑर्गेनाइजेशन एक पार्टी हो जाए, चाहे किसी भी साइड से हो, लेकिन एक साइड से इंटरनेशनल ऑर्गेनाइजेशन का होना जरूरी है. वैसी ट्रीटीज जो गवर्न होंगी वो 1986 वीसीएलटी आईओ से गवर्न होगी. शुभम, स्टेट्स आईओ, yes, as well as IO. Wonderful, thank you. Soumya, it is an extension. Yes, because when Vienna Convention on the Law of Treaties was being drafted, the initial intention was to have all kinds of treaties. That is, treaties between states and states, treaties between states and international organizations, treaties between international organizations and international organizations. In fact, if you go by larger discussion within International Law Commission and subsequently Vienna Conference, you'll find that they were also trying to comprehend initially, of course, at an initial level, they were trying to comprehend those treaties which are made by non-state entities other than states and international organizations. Subsequently, it was decided that one particular document covering all such treaties might not be strong enough. It might weaken the structure which is being created by Vienna Convention on the Law of Treaties, and therefore, what was ultimately decided to drop other entities and international organization, and only to confine VCLT 1969 to treaties signed between states. Okay, there is a long comment. Deepak, the parties to the present convention, considering the fundamental role of treaties in the history of international relations, recognizing the consensual nature of treaties and their ever-increasing importance as a source of international law, principles of free consent, good faith and pacta sunt servanda. This is the preamble of. Yeah, this is the preamble. Deepak, do you have anything specific to say? Thank you for this. Thank you for putting this preamble here. This preamble to VCLT 1969, if I'm correct. Yeah. Deepak, you have anything specific to add in relation to this preamble? Okay. All right. Okay. Let me move ahead then. Yeah, so, yeah, why was I talking about these two things? Why were we talking about VCLT, VCLTIO? I don't know, I almost lost track of the initial discussion which we had.
National, we were talking about those.
Yeah, thank you. Thank you. Okay, yeah, so the last form of classification which we are talking about is intergovernmental or supranational. Yes, now I remember. This word called intergovernmental is something which we have already seen. So when we looked at the definition of international organization, and we specifically invoked 1986 Vienna Convention on the Law of Treaties between states and international organizations and between international organizations, to see that there is a one sentence definition that international organization means intergovernmental organization, meaning thereby that international organization would be a product of governments coming together, two or more governments coming together and calling for the establishment of an international organization. Now that is true. When we talk about intergovernmental organization, there is often an argument made. That governments do control the very function of each and every function of an international organization. There is some level of control which is some level of control which governments maintain when it comes to those international organizations which are product of, say, intergovernmental negotiation, ultimately culminating into an international organization. But of late, there is a discussion that there are certain international organizations which can be considered as supranational. When we say supranational, what we mean is that these international organizations might have the capacity to regulate the conduct of states beyond their control after one point of time. And the classic example, in fact, the only example which is often identified, and this is the word which is reserved for such international organization, is European Union. And there are quite a few grounds which are identified when we talk about European Union and how, for instance, it has turned out to be so powerful. When it comes to European Union as an international organization, it is often identified that within European Union, the decision, for example, is taken by majority vote. And therefore, it is entirely possible that a member state might be forced to adopt a particular regulation, a particular conduct, a particular behavior, which that particular member state opposed. But that's not the only thing. That is the first aspect which is identified. The second aspect which is identified is that the moment a decision is taken through the specific institutions of the European Union, it prevails over the conflicting domestic law or municipal law. So the point which I'm trying to make is that if at all there is a conflict between EC law and the municipal law of the country, then EC law would prevail. That is, the law of the European Community would prevail. Again, this is a very, very serious. Aspect for many countries. The third is that quite a few laws which are passed by European Community, they can be directly enforced in the municipal legal system of respective states. Therefore, if a law has been passed by, say, European Community, it need not be required that another member should invoke that particular law against another EC member. Rather, even a citizen can, for example, go and invoke that particular law against his or her own state. All these factors combined together, it is often quoted in academic literature that all these factors combined together produce a supranational entity kind of a thing. An entity which is so powerful that it exists above member states. Many a times a distinction therefore is made between intergovernmental organization where proper control, proper check and balances are maintained vis-a-vis the international organization. When it comes to supranational organization, it is often said that this organization has become so powerful, especially European Community, has so powerful that they significantly regulate the conduct of member states when we combine all these factors together, the factors which I just identified. And therefore, the crux of the argument is this, that EC, by its very nature and function, appears as if it stands above member states, that member states do not have complete control over the functioning of EC. And therefore, this particular term emerges called supranational, something which is bigger than the nation state. Often this particular term is reserved for European Community. As I said, this differs from intergovernmental organization because in case of international organizations in general, there is a presumption that states generally guard their sovereignty in a very possessive manner. And because they guard their sovereignty in a very possessive manner through rules and processes, through the structure, it always tried to keep control over the functioning of an international organization. And therefore, an international organization in that sense remains very much under the control of its member states. Certainly, such international organizations, it is said, cannot be equated with that of the European Community, where the institutions per se have acquired a quite prominent position. Be that as it may, these entire four types of classifications which we talked about, beginning with, say, function, going to membership, going to further political and technical issue, and then talking about intergovernmental and supranational kind of international organization are again classifications only for convenience. These are not classifications which are embedded in the treaty itself. That is, as a matter of pure legal technical analysis, it is not necessary that you first need to classify an international organization. Such classifications are rather needed to understand the nature, functioning, objective, and the broader law relating to an international organization more clearly. That is all the purpose of such forms of classification is. Having said that, there is not one textbook on international organization. I'm talking about good textbooks. So please don't consider those books and pamphlets which are sold and celebrated at the campus law center and the faculty of law. I'm talking about really accepted textbooks all over the world, where you will find that each and every textbook on international organization will begin its analysis with a classification of international organization, and the list of classifications can be broad and extensive. But these are the four broader forms of classification which exists as a matter of general policy. That's all. If you have any concerns, any remarks, any statements, I would be happy to listen to it. Maybe try to comment on it. Anything?
No, sir. Bye-bye.
No, sir. Okay. Fine.
Sir,
Yeah. Someone said something. Yeah.
वो कुछ स्टूडेंट्स ना रिकॉर्डिंग मांग रहे थे आपकी लेक्चर्स की.
Okay, Pran. As I said, I don't have a problem with recording, but fine, I will try to do it. But there's one specific issue which I've said, that I often become very conscious when I speak, when it comes to recording. That's my own problem. Of course, I have to overcome that. Fine, we'll try to solve it. But
और इनविटेशन लिंक भी सर, इन विच कुछ स्टूडेंट्स जो सीनियर्स हैं.
Yeah, because quite a few requests which I have, I don't have a problem. उनको आप बोल दीजिए मुझे मेल ड्रॉप कर दें, या फिर आप एक लिस्ट बना लें, मुझे कोई प्रॉब्लम नहीं. I mean, invitation links are the easiest part. Already quite a few of them are already here from your senior batches. But that's all right. वैसे कोई दिक्कत नहीं है, आप उनको बोल सकती हैं, या फिर आप खुद मुझे बता दीजिए. Deepak, Article 71 of the 1969 and 1986 Convention on Consequences of the Invalidity of a Treaty which conflicts with peremptory norm of general international law. Okay, so Deepak, is it a question? Yes, sir. जैसे Article 71 कहता है